value, even though the value of these materials may be nominal or difficult to ascertain. These authorities would support the view that candidate-related opposition research given to a campaign for the purpose of influencing an election could constitute a contribution to which the foreign source ban could apply. A campaign can be assisted not only by the provision of funds, but also by the provision of derogatory information about an opponent. Political campaigns frequently conduct and pay for opposition research. A foreign entity that engaged in such research and provided resulting information to a campaign could exert a greater effect on an election and a greater tendency to ingratiate the donor to the candidate than a gift of money or tangible things of value. At the same time, no judicial decision has treated the voluntary provision of uncompensated opposition research or similar information as a thing of value that could amount to a campaign or a contribution under campaign finance law. Such an interpretation could have implications beyond the foreign source ban and raise First Amendment questions. Those questions could be especially difficult where the information consisted simply of the recounting of historically accurate facts. It is uncertain how courts would resolve those issues. 2. Willfulness. Even assuming that the promised documents and information that would incriminate Hillary constitute a thing of value under campaign finance law, the government would encounter other challenges in seeking to obtain and sustain a conviction. Most significantly, the government has not obtained admissible evidence that is likely to establish the scienter requirement beyond a reasonable doubt. To prove that a defendant acted knowingly and willfully, the government would have to show that the defendant had general knowledge that his conduct was unlawful. This standard creates an elevated scienter element requiring, at the very least, that application of the law to the facts in question be fairly clear. When there is substantial doubt concerning whether the law applies to the facts of a particular matter, the offender is more likely to have an intent defense. On the facts here, the government would unlikely be able to prove beyond a reasonable doubt that the June 9th meeting participants had general knowledge that their conduct was unlawful. The investigation has not developed evidence that the participants in the meeting were familiar with the foreign contribution ban or the application of federal law to the relevant factual context. The government does not have strong evidence of surreptitious behavior or efforts at concealment at the time of the June 9th meeting. While the government has evidence of later efforts to prevent disclosure of the nature of the June 9th meeting that could circumstantially provide support for a showing of scienter, that concealment occurred more than a year later, involved individuals who did not attend the June 9th meeting, and may reflect an intention to avoid political consequences rather than any prior knowledge of illegality. Additionally, in the light of the unresolved legal questions about whether giving documents and information of the sort offered here constitutes a campaign contribution, Trump Jr. could mount a factual defense that he did not believe his response to the offer and the June 9th meeting itself violated the law. Given his less direct involvement in arranging the June 9th meeting, Kushner could likely mount a similar defense. And while Manafort is experienced with political campaigns, the office has not developed evidence showing that he had relevant knowledge of these legal issues. Difficulties 3. Difficulties in valuing promising information. The office would also encounter difficulty proving beyond a reasonable doubt that the value of the promised documents and information exceeds the $2,000 threshold for a criminal violation, as well as the $25,000 threshold for felony punishment. The type of evidence commonly used to establish the value of non-monetary contributions, such as pricing the contribution on a commercial market or determining the upstream acquisition cost or the cost of distribution, would likely be unavailable or ineffective in this factual setting. Although damaging opposition research is surely valuable to a campaign, it appears that the information ultimately delivered in the meeting was not valuable. And while value in a conspiracy may well be measured by what the participants expected to receive at the time of the agreement, Goldstone's description of the offered material here was quite general. His suggestions of the information's value, i.e., that it would incriminate Hillary and would be very useful to Trump Jr.'s father, was non-specific and may have been understood as being of uncertain worth or reliability, given Goldstone's lack of direct access to the original source. That uncertainty over what would be delivered could be reflected in Trump Jr.'s response. "If it's what you say, I love it." Emphasis added. Accordingly, taking into account the high burden to establish a culpable mental state in a campaign finance prosecution and the difficulty in establishing the required valuation, the office decided not to pursue criminal campaign finance charges against Trump Jr. or other campaign officials for the events culminating in the June 9th meeting. C. Application to harm to ongoing matter. 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 Harm to ongoing matter.